Dear readers, a reading of article written by C.A. Bimal Jain sir. Title of the article is Assessee permitted to rectify its GSTR-1 for FY 2017-18 and 18-19 to avail ITC benefits. The Hon'ble Orissa High Court in Messrs. YB Construction Private Limited versus Union of India and others, writ petition C number 12232 of 2021, dated February 2022, 2023, has permitted the Assessee to rectify the error of mentioning V2C instead of V2B in Form GSTR-1 at the time of filing of GST return, holding that the assessee would be prejudiced if it is not allowed to avail the benefit of ITC, directed the respondent to receive the corrected GSTR-1 manually and upload the detail on the web portal within 4 weeks. Fact of the case is Mrs. YB Construction Private Limited had committed a mistake while filing the GST return under Form GSTR-1 for the period 2017-18 dated October 16, 2017 and November 25, 2017, and for the period 2018-19 dated January 30, 2018 and March 30, 2019, wherein V2C instead of V2B was mentioned. The petitioner sought to correct the error in order to receive the ITC benefit from the principal contractor. The last date for rectifying the return was April 13, 2019. The Revenue Department stated that once the deadline for rectification of the forms was crossed, then no further indulgence would be granted to the petitioner. We agreed the petitioner has been filed. The petitioner contended that the error came to be noticed when the principal contractor held up the legitimate running bill amount of the petitioner by informing it about the above error, and thereafter it has been making a request to the respondent to permit to make the corrections. Issue whether the petitioner be allowed to rectify the error committed in Form GSTR-1. Hon'ble Orissa High Court in writ petition number 12232 of 2021 held as under noted that allowing the petitioner to rectify the mistake in its GST return will not cause any loss to the respondent, as there will be no escapement of tax. However, denying the request will prejudice the petitioner who is entitled to receive the ITC benefit. Relied on the judgment of Honorable Madras High Court in the matter of Sun Dicam versus the Assistant Commissioner of ST, writ petition number 29676 of 2019 or dated October 6, 2020, wherein the plea of the assessee was accepted and it was permitted to file the corrected form, permitted the petitioner to resubmit the corrected GSTR-1, directed the respondent to receive the corrected GSTR-1 manually and facilitated the uploading of the detail on the web portal within 4 weeks. The comment of the author is that the above judgment brings up a significant issue concerning whether the assessee would be allowed to rectify the error while filing its GSTR-1. In this regard, recently in a similar matter, the Honorable Orissa High Court in Messrs. Shiva Jyoti Construction versus the Chairperson, Central Board of Excise and Customs and others, writ petition C number 18216 of 2017 dated January 12, 2023 had permitted the assessee to rectify its GSTR-1 filed for the month of September 17 and March 18 in order to claim ITC benefit by the recipient, wherein V2C was erroneously mentioned instead of V2B. It was held that the assessee will be unnecessarily prejudiced if it is not allowed to avail the benefit of ITC. To know more about this case, you can watch the video recorded by Bimal Jain sir under title Legal Jurisprudence V2B Supply, wrongly shown as V2C, credit denied to buyers. Further, the Honorable Karnataka High Court in Mrs. Wipro Limited versus the Assistant Commissioner of Central Tax and others, writ petition number 16175 of 2022 dated January 6, 2023 has allowed the assessee to rectify the error committed at the time of filing of forms and submitting GST return for FY 17 to 2020. It was held that the error committed by the assessee in showing the wrong GSTIN in the invoice, which was carried forward in the relevant form, is bona fide error which has occurred due to bona fide reason, unavoidable circumstances, and sufficient cause. Hence, Circular Number 183/15 of 2022 GST dated December 27, 2022, which allows rectification of such bona fide and inadvertent mistakes, would be directly and squarely applicable. To know more about this, you can watch the video recorded by C.A. Bimaljan sir under title Karnataka High Court Relevance of Circular on Difference of Credit in GSTR 2A versus GSTR 3B. Thank you. You can read this article under under title Assessee permitted to rectify GSTR 1 for FY 17-18 and 18-19 to avail ITC benefit. It is available under articles menu. Thank you.